The National Prosecuting Authority is expected to hand over new directives from the National Director of Public Prosecutions that the docket 375 will be moved to the DPP in the North Gauteng Division. Now, these details were revealed in a recent letter addressed to Adv Malesele Teffo and instructing Attorney TT Thobane by the state. The letter comes just a few days to the resumption of trial and amid a lengthy postponement for accused numbers 5's lawyers, Andile Mshololo, to study the said docket after it emerged during cross-examination of the first state witness. Newzroom Afrika's Mnisi is live for us just outside the court. Linda, very good afternoon to you. The matter is set to get underway, but in this letter, we know that the NPA says the ultimate decision on this docket will be taken after the current trial. Talk to us about what it all means.
Well, Paul, this particular docket is likely to take center stage for many reasons. But you'll remember that just last week we saw that letter from the NPA, the one that you make reference to. It's the new move around this particular 375 docket. Now, for those who do not know, this 375 docket is the one that has a different, theory to the one that is currently in this court behind me, the one currently on trial, and it basically was opened in 2019 after police officers who were part of the initial investigating team felt frustrated by the lack of progress in the case that is currently now in trial. We know how long that has taken, but it actually lists Kelly Khumalo and all the people who were in the house as prime suspects, saying that the notion that there was somebody who entered into the house was in fact false, and the people and the person who might have shot Senzo Meyiwa might have been in the house at the time of that particular shooting. Now, this particular letter, Paul, basically says that they are now moving jurisdiction. That docket is going to be moved from the South Gauteng Division of the NPA to the North Gauteng Division, the same way that case 636, which is currently in this court, was moved to Pretoria. You will remember that Senzo Meyiwa was shot in the East Rand, which means that the jurisdiction would have had to be in the South Gauteng Division. But what is also important about this letter is that it says a decision on 375, the decision to prosecute, whether or not to prosecute Kelly Khumalo and those in the house, will be taken post this current trial. A large portion of it would depend on the credibility findings that would be made by this trial court, which means that they would have to take into account the credibility of these particular witness. The background around this letter is that there was another letter after legal representatives sought clarity on this 375 docket. You will remember the NPA moving to clarify that the decision on that unsigned indictment, which stated that Kelly Khumalo and the likes are supposed to be prosecuted, was the opinion of a junior state prosecutor, and that it had no merit. So now the decision to move this docket comes from the National Director of Public Prosecutions, which is on a national level. Now, there are questions around why exactly the state is moving to take a decision on this 375 case post the conclusion of this particular trial. I spoke to a legal analyst, and this is what he had to say.
It worries me if the NPA would say that, because what I would have expected the NPA to do is to go through a fine comb on the second docket and say, how many of these witnesses and the statements that we have on this particular docket actually help to bolster our case? Are there any contradictions in any of the statements with the ones that we are currently running with? If they are, let's find a way of mitigating those instances in which maybe people would be not telling the truth, would be lying as to the sequence of events that took place. And if it needs be, and you need to prosecute someone, rather do it simultaneously rather than waiting and only prosecute at a later stage. Because the results which we are going to have is that if the state comes on Monday and says, we are not pursuing this particular case, they are basically saying all the witnesses that have stated on the 365 case are fair game. The defense can then subpoena them and say, please come to court and give evidence as to what exactly happened on that day. That's the last thing you want to happen as the NPA, because you are not going to have control over that particular witness in terms of what they bring to the table in terms of what they bring to the table, in terms of any credibility that is there. Now, my understanding would have been, since the docket has been opened a long time ago, investigations were done and dusted. Why are you waiting up until the current case has been concluded before you move on? The current case has no bearing whatsoever. If you want to prosecute them for lying at a later stage, prosecute them for lying within this particular trial, in which you only have one chance to prove the element of guiltiness.
Right, with that reaction, Linda, I suppose there's more questions now than answers, of course, since we learnt of the docket, the second docket. But in response to the questions around this docket, the NPA has said that there's nothing untoward about moving it, and it's not really necessarily an about turn.
Yes, indeed, because, like I said, it comes at the backdrop and pour of that letter which was read out in court, where the NPA said that the decision on that particular indictment, unsigned indictment, was basically the opinion of a junior state prosecutor that had really no merit. Now, it moved to clarify the issues around the jurisdictions and making reference to the current case which is before this court, that it did indeed make a similar decision to move this particular case from the South Gauteng Division to the North Gauteng Division. So there's nothing untoward. It's not necessarily a new thing to have a docket being moved from one division to the next. So it aimed to clarify those stance, which really looked like an about turn. But if you look at the roles of, the NDPP as well as the DPPs, who come really from a provincial as well as district, point of view, it really aims to then clarify the lines, the powers, that the NDPP has in terms of making such decisions of moving these cases to different jurisdictions, because ultimately the DPP can only take a decision on a docket that is within its own jurisdiction. But largely this is about really the decision to say we will take a stance on this docket post this trial, and that is what is being questioned, the strategy that is now being implemented by the NPA.
Very well, Mnisi, let's leave it there for now.